managed to increase their effective use of out-of-court resolutions. The starting point for that is our crime resolution tracker, which if you haven't seen, it's worth taking a visit to our website. We update this every year and we'll be updating it again in August with the latest published government data. I know it's small text, but what the crime resolution tracker does is basically rank police forces on how on their use of out-of-court resolutions versus their use of charge. So these are all the police forces, that's the names of all the police forces in the very small text. And what you can see is the grey is the kind of total bar is all positive outcomes, which we include outcome 22, by the way, but also out-of-court resolutions and charge. So the total bar is all positive outcomes. The grey shows you proportion charged. The dark orange shows you proportion out of court, given an out-of-court resolution, and the light orange in the middle is what's given an outcome 22. So this is on our website. You can have a look at it. We also have breakdowns for children and adults where forces have provided that data. And to us, this shows that there's huge variation across police forces in use of out-of-court resolutions versus charge. So within the current national policy framework and legislation, forces are applying it really quite differently, and use is really varied. So at the top is Difford Powys, and I think 55% of their positive outcomes they deal with via out-of-court resolution or outcome 22. At the bottom, Cleveland, it's 12%. So it's huge variety, and all sort of percentages in between. So we spoke to 9 police forces at the top of our tracker to understand kind of what explained their position in our ranking. So we're just going to talk about some of the findings from those interviews today. We're going to talk about some common success factors. We're going to talk about some innovative practice that we heard about, and also some issues that even the forces that we spoke to are struggling with. So I'll kick off. I'm going to hand over to Ella for a bit, and then we'll come back to me. And we're also going to speak to Claire and Martin from Sussex Police, who've kindly joined us. They took part in our research, and they're going to talk about a few of the pieces of innovative practice happening in Sussex that we thought were interesting and worth sharing. So the first kind of theme to our findings in our research was around leadership and culture within the forces that we spoke to. A common theme was that the police leadership in many of these forces recognised the value of out-of-court resolutions and diversion. So interviewees we spoke to felt like that was part of the explanation about how they had managed to basically be kind of high in our crime resolution tracker. So that kind of direction from senior leadership, which is supportive of out-of-court resolutions, then has an impact on the communications that go out to officers, funding decisions that are made, performance measures maybe, all of which impacts frontline officer behaviour and their use of these out-of-court resolutions options. So several forces had senior leadership who were accepting that charge wasn't the only worthwhile outcome. You can see this quote here from one interviewee who said in their force, charge does not necessarily equal success. And in some cases, full diversion, i.e. not giving an out-of-court resolution, but giving no further action instead, perhaps with a referral to another service. In some forces, that was also encouraged in the right circumstances. This second quote here from another force who said, from no further action all the way up to charge, every outcome has its place. So that there was this broad-minded leadership basically on what counts as a good resolution, and that did have a big impact. It was a major success factor. We came across some risk of up-tariffing in some areas. So this is forces under pressure to use more positive outcomes per se, and that might mean moving things that might otherwise be given a no further action because it wasn't deemed in the public interest to do any more, moving it up to a community resolution or a caution. because then it counts as a detection or a positive outcome. So that's a kind of unhelpful pressure in our view, and it did exist in a couple of the forces that we spoke to, because it means people aren't diverted entirely when perhaps they should be, and it's giving an out of court resolution for the wrong reason, not because it's best for the person or best for the victim. So if you're a police force thinking about what to do about that, I mean, firstly, do you have a supportive chief constable? You know, if so, use them, as many of our forces that we've spoken to in the past are doing. You can use them in your communications to promote out of court resolutions to frontline officers. If you do that, it seems like it is being impactful, based on our conversations with forces. Maybe you can propose ideas to them to support effective use of out of court resolutions, you know, like funding a central team of expertise. We can go on to that. It doesn't need to be the chief constable that's supportive. In some forces we spoke to, you know, it was another senior officer, and they were the ones who championed out of court resolutions. And if you have someone like that, or if you, you know, what support can you give them to do that? If you don't have, and I know some forces don't have chief constables who feel like out of court resolutions and increasing their use is what they want to be doing right now, is there someone else you can find within the senior leadership team who could act as a champion for you? What evidence do they need to reassure themselves and to champion effectively? We have done a lot of research, and we know of a lot of other research about why out of court resolutions can be beneficial, be it, you know, to do with court backlogs, cost saving benefits, victim satisfaction. So if you're a police officer kind of stuck about how to make that argument, get in touch. We're keen to hear from you. We're keen to share that research with you, or to hear what else your chief officers are concerned about, so we can maybe do some further research to assist you there. And I'll just say as well, on the kind of culture point, even if you're in a force where you feel like the culture isn't really there around out of court resolutions use, you can start small. And that was what some of our forces were doing. For example, they'd started with children and out of court resolutions. So trying to start small, building a culture about, you know, maybe giving no further action for children and referral to services, as one force said, you know, to let the right people deal with it, to avoid that child being criminalized. So that was kind of a successful approach for some of our interviewees. I'm going to hand over to Ella to pick up on the next couple of slides.
Thanks, Vanilla. Okay, so communication and training was another big theme. It is a really mammoth task to build, you know, awareness and understanding, and then also support for out of court resolutions within a police force. We know that lack of awareness of the different out of court options amongst frontline officers is a really major barrier to their use. So it's an important task, but also a pretty hefty task. With this in mind, the leads we've spoken to have really gone to very, very big efforts to promote out of court resolutions amongst their force, and then in turn boost their uptake. They very much used every tool at their disposal, and it was a very continuous effort. The work was never done. So yeah, they used a very big and varied range of both comms and training to kind of promote awareness and use. How did they achieve this? So first of all, something that many of the leads we spoke to felt was important was having an in-person presence in police stations. I appreciate that, you know, police forces are different and they cover different geographical areas, so it might be easier for some forces more than others to have an in-person presence. But also the different forces we spoke to did cover a kind of wide variation of area sizes, and many leads still felt it was really important to have this in-person presence. Some would do a rota system, so, you know, one person from the team would be in a police station once a month or once every other month. And having an in-person presence in a police station basically allows you to provide officers with, you know, information around out of court resolutions, answer any concerns, and basically promote their use on the ground while decisions are being made. A quote that really encapsulates this from one of the leads we spoke to was, "Once officers come into the police station, they can't escape us. If they bring someone into custody, my team are there in the custody suite going, 'Right, what have you got for me today? Is anyone suitable for a caution?' They can't move without us." Obviously, in this situation, we as Transform Justice would be hoping that its cases being down-tagged from a charge to a caution. Leads were also delegating comms and training. So as we said, it's a big task, but you don't need to do it by yourself. They would do this by delegating to other teams that also have inputs with frontline officers. So one force delegated some of their comms around out-of-court resolutions to their victims care hub, as they also had an input with frontline officers. All leads would be doing this through delegating to individual officers who are interested in out-of-court resolutions and kind of getting them to spread the word to their colleagues about them. We're going to hear a bit more about Sussex's out-of-court resolution champions in a little bit, which was a great example of this. And the leads also tried to make their comms and training as responsive as possible to their officers. So they would think about, what information do my officers need to start using out-of-court resolutions, and also what concerns or reservations do they have about using them, and then they would use comms and training to address these needs. A really good example of this is one lead we spoke to. Their force monitored out-of-court resolution use, and whenever there was a dip in use, they would basically do mop-up trainings, they called them, or refresher trainings for frontline officers to kind of refresh their knowledge of out-of-court resolutions. It's also important to get feedback on your comms and training and then adjust accordingly. So we saw leads use, surveys on different comms or guidance or tools they were putting out, or tests and surveys at the end of trainings to kind of see how effective they were and how much knowledge officers were taking up from them. So streamlining was also considered very important. The leads we spoke to felt that basically making the out-of-court process as easy and simple to use was a really, really important factor for increasing uptake amongst frontline officers. The quote on the right here from one of the leads who said, "It's nice and easy, and absolutely that is a key element to why police want to do it." Another lead told us that streamlining was single-handedly the most important factor for increasing use of out-of-court resolutions amongst their force. Leads told us that, frontline officers are very busy, they have limited time, and so it really helps if disposals are simple and easy for them to use. We at Transform Justice know that, from previous research we've done with frontline officers, that when out-of-court resolutions are a bit of a faff to use, it can really prevent officers from actually using them. And also, apart from increasing use, streamlining also helps to ensure that out-of-court resolutions are both used appropriately and consistently. So really a lot of benefits to streamlining the out-of-court process. But how are forces streamlining? What are they doing? So a really key thing that we saw across a lot of the forces we spoke to was introducing a central out-of-court team to administer out-of-court resolutions, and then also to be providing officers with, support around their use and guidance. The quote on the left was from a lead who said the team's worth their weight in gold. So, central team was very valuable to that lead. And in some forces, the team also had the power to make decisions on suitability and issue suspects with out-of-court resolutions. And another way that we saw streamlining the process was through leads introducing tools to help officers use out-of-court resolutions. A good example of this is a phone app that allowed frontline officers to issue community resolutions on the go, so while they were out and about in the community. And vulnerable suspects. So this was another theme, another area that we looked at within the research. It was how forces were assessing and responding to suspect vulnerability within the out-of-court process. And this was actually an area where we saw both some really good examples of practice, but also it was an area we felt some forces had a bit of room for improvement. So most forces we interviewed did not have a suspect needs assessment in place to identify someone's vulnerabilities. Some forces used police database flags or custody risk assessments, which, while these can alert officers to, the need for an interpreter or an appropriate adult, they don't usually help identify more complex vulnerabilities. But this wasn't the case for all forces. Some forces did use a suspect needs assessment, normally to identify vulnerabilities after a suspect had been issued a conditional caution, so helping to choose what interventions they were going to be attaching to the caution. Thames Valley had a really great example of this. they had a caution clinic where once a suspect had been issued a conditional caution, they would go to the clinic and do a voluntary needs assessment with a caseworker, which on the right-hand side of the slide, this is a page from the needs assessment. And this would help them identify vulnerabilities such as mental health needs, substance use, financial difficulties. And by identifying these vulnerabilities, it would help the caseworker both tailor the intervention to the suspect's needs, but also identify, any barriers that due to the vulnerabilities, the suspect might be struggling to comply with the interventions of the caution. So as the lead said, they were always thinking, are we setting them up to fail? And actually, they told us about some situations where once identifying a suspect's vulnerabilities, it would prompt the staff at the caution clinic to downgrade the caution to either community resolution or a simple caution if they just felt that due to the suspect's vulnerabilities, there was just no way that they would be able to realistically comply with a conditional caution. So an example of this was if the suspect was street homeless. So while this is really, really great practice, we also think that forces could actually use needs assessments earlier in the process, ideally before a disposal decision is made, to ensure that the resolution given to the vulnerable suspect is appropriate in the first place. Research done by Rand suggests a tiered approach where assessments at different levels of in-depthness are used at different stages of the out-of-court process. So, pre-disposal decision, and then maybe later on down the line to also help decide interventions. We also found that some forces were risking overloading vulnerable suspects with too many interventions to address their different needs or vulnerabilities. So we know that suspects with vulnerabilities can really struggle to comply with interventions due to these vulnerabilities. And while it is great that, interventions can be tailored to their needs and to be supporting them with their needs, it's also important to recognise that less can be more with out-of-court resolutions. So if a suspect has a lot of vulnerabilities, trying to address them all through, multiple interventions may overwhelm the suspect and ultimately means they can't comply with the conditional caution and then risk being charged. Equally, where a suspect has a very entrenched vulnerability or complex vulnerability. So, for example, if a suspect has entrenched drug use, an intervention as part of a conditional caution around drug use might not be able to get to the kind of root of their issue, and again, may risk them ultimately being charged because they just aren't able to comply. So in a similar vein to this, it's also important to recognise that sometimes other agencies can be better placed at supporting vulnerable people than the police. So, for example, external services or third sector agencies. And we'd recommend considering, referring to these services or agencies, either as part of an intervention or conditional caution, as the whole intervention, or as a voluntary referral. And a great example of this, which again, we're going to hear about in more detail down the line, is Sussex had a conditional caution for vulnerable women where the only condition or the only intervention on the caution was for the female suspect to attend the first appointment with a local women's service. Once they had done this, the condition was complied with, and any further support the woman received was very much just between her and the women's service. Now I'm going to pass you back to Fionnuala to speak about scrutiny and reassurance.
Thanks, Ella. Yeah, just one more slide from us. So the kind of final theme, we were interested in finding out how are police forces reassuring themselves that they're using out-of-court resolutions effectively and appropriately, and also how are they reassuring others of that. So from our research, we found that scrutiny of out-of-court resolutions tended to focus on compliance with local and national guidance, and most forces we spoke to had pretty robust systems in place for doing this. They did dip sampling. I think in one force they looked at every single out-of-court resolution, which you can do if you're a small enough force. Or they had scrutiny panels in place, which also conduct dip sampling, but they involve other agencies in that too. We thought it was interesting and good practice that in some cases forces use expertise from elsewhere in the force, so they weren't just kind of relying on their own team to do all the scrutiny. So one force asked their audit team to kind of conduct a standalone review of their out-of-court resolution use and give them feedback. Another, I think they had kind of a regular review by their corporate analysis team. So those are teams, obviously, that have skills in kind of scrutiny analysis and evaluation. So, if you're a police out-of-court resolutions team, use those skills and ask them to review and give you feedback. There's also a really good example in our report from Hampshire of involving other frontline teams in dip sampling, in the dip sampling process. So there, every quarter, they invite representatives from different teams across the force, so like investigations or neighbourhood policing, to help with dip sampling. I think it was 150 out-of-court resolution cases. So that's great because it kind of spreads the load. But also then those team members go away with an improved knowledge about what a good out-of-court resolution looks like and how they're actually working in practice, and they bring that back to their teams. So we thought that was great, both for scrutiny, but on the kind of comms and training point that Ella talked about earlier. What we, in terms of gaps, is that scrutiny mechanisms tended to overlook other measures of success beyond just compliance with guidance. So, we think it's not just about whether it complies with guidance. I think a kind of effective out-of-court resolution use should be looking at other questions too. And we found forces tended to be lacking the data or the structures and or the expertise to answer some big questions that are like, how are victims experiencing out-of-court resolutions? One force said, we don't really look at victims, the attention is on the suspect, to be honest. Do out-of-court resolutions reduce the likelihood of that person committing another crime? I think forces we spoke to mostly said that saw reoffending data analysis as tricky to do, and were kind of a little bit at a loss there about how to proceed, or felt like they didn't have the confidence in what data they did have to be able to do that effectively. And thirdly, are some defendants more likely to be diverted from court than others? This is a really important question if we're thinking about kind of scrutiny of out-of-court resolutions use. And police forces just don't have the kind of at sea here. They don't have the skills or the expertise to be able to do that, and they need guidance and support in scrutinizing data on disparities that might be race or otherwise, and working out how to take action and what they find. On that, we think there is also a need for a national piece of research on disparities in out-of-court resolution use, with recommended good practice and solutions that all police forces can apply. So it's not just the onus of the local police force to kind of look at it locally. And we think there's a bit missing about, are we missing opportunities to divert cases from court? Not just are we using out-of-court resolutions appropriately instead of, charge, but the other way around. Is anything being charged that could instead be diverted and resolved by the police instead? I'll kind of leave talking about our findings there and bring in Claire and Martin from Sussex Police, who are going to just tell us a little bit more about a few of the pieces of good practice going on there. Claire and Martin, thank you so much for joining us. I'm just going to ask, we're going to have a bit of a conversation for about 10 minutes, and then really keen to hear any questions from the audience, which I'll hand back to Adam for. So firstly, Ella was talking about out-of-court champions. Claire, can you tell us what are out-of-court champions? What do they do?
Out-of-court champions are, I'd say they're part of our bigger comm strategy. So we've got a comm strategy of how we put things out across the force, and training and news about things like our new team and things. And out-of-court resolution, out-of-court resolution champions play a part on that. So they are a network of people across the force, mainly sergeant and PC rank, who act as our allies, really, talking to people and departments. They spread the word about these changes. If we've got training that we want to disseminate, they will assist with that. We've got a role profile for them, is probably the most important thing to say. So I was very fortunate, they were created and I was gifted them by my colleague, Sergeant Lauren Bell. So she set it all up before I joined, and I've had a chat with her about the work she put into that. The role profile is very much the first sort of thing to start with, and that's all around how we want people to be a point of contact. It's about upskilling people so they can then disseminate that amongst their teams. So they're that person, you know, if they're the trusted person on the team that people go to anyway, it would be silly not for us not to use that to get our message across as well.
How have these champions been helpful for your team?
Oh, they've been really helpful with them. Certainly with setting up our new team. They've had all of the things before everyone else. They've had time to ask questions. When guidance has been put out, I've been able to use some of the network, test some of the guidance, get some of their feedback on it really early and say what works or what doesn't land quite right, and have changed a few bits as a result of it. So yeah, so then really good.
So they're not just kind of helping with disseminating, but they're also being a bit of a test bed from a kind of other teams about how any new guidance or policies is going to land.
Yeah, and they're very much sort of our ears on the ground. So if they're hearing things that we probably wouldn't hear when we're popping in and out of offices across the county, and I think Stu and Ella said, you know, sizes of counties vary. Sussex is quite big geographically, so we can't, even with our team, be everywhere at once or as much as we'd like to be. But if they're picking up that people are having particular issues with something, we can hear that nice and early because we're getting that, we've got those communication channels open with them.
Yeah, that's fantastic. Moving on to another area that Sussex have been working on around referral to women's centres. So this is what Ella was talking about earlier. So one of your interventions, Martin, for a conditional caution, refers women to a women's centre, and the only condition is that she attends an initial appointment, and if she does that, she's completed the condition. So why, firstly, did you introduce what some might say is quite a light touch condition?
It was born out of recognition that, you know, people have complex needs, and there's a lot of reasons why somebody may choose to offend or feel that they need to offend, and that kind of helpful approach and that restorative and reparative approach can't be forced. So it would be pointless putting a conditional caution into place where we say to somebody, you must you know, go along to this women's centre and make your life better. They then wouldn't really buy into it. They wouldn't really engage with it. They would just be doing it because they felt like they had to. So by setting the condition to just be that one touch, go and see them, see what they can do, see what they can assist you with, then we back off and we leave that person in the hands of somebody who's in a position to, you know, help them transform their lives and stop the offending much more than we are. It is something that Claire is really passionate about, particular, and she speaks with the that women's centre very, very regularly around how we can better work with them.
So Claire, why was it important that the support's provided by a third sector agency instead of the police?
I mean, I think it's because of that barrier that we all know is there between the police and a lot of the people that we deal with, certainly people who are on the offender side of the equation, that there is going to be a natural barrier. And we hear that when we're talking to people. There's also the other agencies that they've got working alongside them. So they're not just, we've got this, or we could refer to that. They can pull everything together. And more importantly, they've got the time to spend with however long this person needs. So whereas we would have to put a finite amount of time into how much time we spent with someone. If they've got someone who needs 3 months worth or even longer, they can make that work.
And what feedback did you receive about the programme? Claire, maybe you want to start with that.
Yeah, we've had some really positive feedback, and we get feedback from the centre about from the women themselves and how useful they found it. We know quite a few of them will continue to work with the centre. Officers who have used the intervention are really like using it, and I think they recognise how meaningful it is. They recognise that it is something that's actually got a good chance of making a difference for these offenders. So that there's some quite positive thoughts about it. And for a specific example of when it's worked really well, because we've got that communication with them and we work alongside them well, there was an offender who had been dealt with for an out-of-court resolution several months before. She'd gone on to have a baby, she'd been supported, she was doing really well as a mum with some extra needs, but was getting help and had stayed out of trouble. But in the background, there'd been another couple of offences rumbling on that took a long time to investigate. So these were going to be coming to be dealt with after she'd already done this work with the Women's Centre. So they were able to contact me, and I was able to liaise with the officers who were dealing with that other case. And we were able to come to a sensible conclusion with it all, which recognised where she'd already reached and how this would be disruptive if we went backwards now.
So it sounds like a kind of brilliant practice to us. Martin, did you get any pushback on this approach from within the force or elsewhere?
No, actually, I think everybody is really on board with it. We did have some difficulties in overloading that women said it was so popular. Actually, we were probably passing them more work than they were able to do. So we had to kind of look at that and work closely with them and look at what their capacities are and see where maybe it was becoming a bit of a reflex condition as opposed to kind of a properly well thought out one. But that's something I think we've resolved now. And yeah, it's really positive. I don't think we've really had any pushback or negativity from it. In fact, if anything, we'd like to use them more than we do.
Fantastic. And then finally on having a central team, which I know Sussex has recently moved to having a central team to administer out-of-court resolutions. Claire, can you just tell us a little bit in brief about how it works, how it's set up?
So we cover the whole force. All conditional cautions come to us, and we also take what we've called them special category community resolutions. So the ones that would previously have been authorised by an inspector on division, which includes DA, hate crime, and anything that has a final score on the gravity matrix of 3 or more. So we ask for all of those to come to us, and they all get viewed and assessed by our DI. They have to come to us to be authorised. So the point we get them at, the sergeant on the frontline team will have got to the point where they've completed their initial investigation, sometimes the secondary investigation, and they're thinking about where they want to go next, disposal outcomes, what we're looking at. If they decide it's probably one for us, they will complete a very short referral form that just covers the absolute must-haves, like have we got enough evidence to charge, that sort of thing. And they send it over to us and we assess it and allocate it to one of our caseworkers. They then do their long needs assessments that we've put together with help from some of the other forces who already had them, including Surrey, and I think possibly Thames Valley as well. So we do that with the suspect before we even think about what conditions that we're going to do. And we've also got some things that we do with victims as well. There's an aid memoir that's been written off the back of the work we do looking at victim surveys.
So why did you introduce this central team? Let's go to Martin. Yeah.
I'll come on that. It was around consistency. We were seeing where we initially just had it was myself and a single sergeant, Lauren Bell, back in the day, just kind of doing dip checking and ownership of policy. We were seeing a lot of disparity in how out-of-court resolutions were being applied across the force. So it was making a bit of a postcode lottery, which obviously was impacting victims, their experiences, and the effectiveness of them as well, less something to be questioned. So we wanted to continue to encourage the use of out-of-court resolutions. We're quite proud of how many we do and quite how open the force is to using them, rather than just always defaulting to charge. But we needed to make sure they're being used effectively, consistently, and legally. We did. There were a number that were being issued where the criteria wasn't met. We'd see reviews that would say, we don't have enough evidence to charge this, so I'll caution them, which clearly is not correct. So it was around being able to offer that consistency to victims, really make effective conditions. That needs assessment is just a huge part of our process, and it's really what we've sold to the force. That needs assessment that we do before we decide conditions is so important, to hopefully drive down recidivism, and to make it consistent, as I say, and hopefully stand up to better scrutiny.
Claire, what's been the reaction to the introduction of the team? Has it been well received by colleagues in the force?
Yeah, we've had a lot of positive feedback. It's slow uptake initially, as we'd expect. We'd anticipated that, and I think anyone.
Oh, Claire's gone silent for me.
Yeah, I'll come in. So Claire, your mic's gone.
Sorry,
I'll
Claire.
come in. Yeah, I mean, as with any change program, I think anybody on this call will have had some experience of trying to bring in change to a police force. It can be very difficult, and it can be, you get a lot of resistance. So we had that initially, but actually we're not even completed our 3rd month yet, and we are now seeing a real steady stream of referrals. We've set up a kind of helpline number, because actually in Sussex all our desk phones were taken away in favour of mobile phones. What we've done is set up a single phone number that somebody on response can call from the scene and get some advice around any out-of-court resolution. That rings every day, which is really positive. And yeah, we've had a lot of positive feedback, and from a lot of different working areas as well. So our op safety, knife crime are really engaged with us. They're really excited about us adding that scrutiny and pushing back against those knife crime ones where there's not suitable. And our hate crime leads as well are really excited about the opportunities to deal more with hate crime in a more restorative manner.
That's great to hear. And I know from speaking to forces out-of-court resolution leads, some would like a central team but are struggling to convince leadership of the funding to get one. Do you have any tips for other forces looking to get funding for a central team?
Yeah, we'd have had those same conversations, I'm sure, with our chief officers, and we all know the benefits to victims, and we all know the driving down of recidivism. We all know all the good reasons to do it. For Sussex, I think what sold it to them in the end was the money, and I think we have to accept that does play a large part. So we actually did some research around how much officer time is spent on an out-of-court resolution, particularly when they have to rework them, and when we sort of looked at the cost of some of the offenders who then go on to re-offend, and so we kind of worked out actually how much money would we save if we weren't for officer times, if we weren't able to do that. Our centralised team as well is actually quite small. We've only got 5 caseworkers, but actually that's enough to take that demand in. So we made a monetary plea to the chief officers, and we kind of evidenced to them that actually, yes, it's going to cost a little bit more money, but actually in the long term you're going to save all this officer time, all these officer hours, and all that extra rework. The crime rates hopefully be going down, because we're going to see less recidivism, and actually that civil litigation risk as well to the force where officers are getting it wrong are all eliminated really from by making that cost analysis.
Fantastic. Thanks, Claire and Martin. Anyone listening, I mean, do read our report, which includes lots more detail about these good practice examples and others. It's on our website. I'll try and put a link in the chat, and I know Nathan will include one in the follow-up email. Ella and I are very happy to take any questions, and Claire and Martin have agreed to answer questions too. So I'll hand back to Adam. Thank you.
Great, thanks a lot. Thanks to you all. I mean, some really important issues there, both about the quantity and the quality of out-of-court resolutions and the ways in which it's been organised. We've got about 10-15 minutes for Q&A. Do put your any questions you might have in the Q&A tab. We've got a number that already come through. First of all, and this is probably Fionnuala and Ella. So there are some questions around where people can access the full reports, more information, and some of the differences between youth and adult. And obviously, your tracker is a resource that people can access. So if you could put any of that in the chat in terms of the kind of the wider information. But we've also, and this is more Claire Martin for you, I think, a number of questions, particularly around the Women's Centre, and the questions kind of focus on the kind of the work you had to do in advance in collaboration with the Women's Centre to set it up in terms of the expectations, because I think you made reference to that you were worried about overloading them in terms of the number of cases that came through and how that was resolved as an issue. So it's partly about the kind of the work that needs to go into establishing that relationship and their expectations of the relationship and how that's been resolved.
I can start to answer a bit of that one initially with the Women's Centre, if that helps. So this was again set up quite a bit of time before either Martin or I were involved in the out-of-court resolutions world, and before our post even existed. I'd say probably about 4 or 5 years ago. It was part of the Female Offender Strategy Delivery Plan, and that's where the money came from. So the finance for the programme that the Women's Centre use comes from the Ministry of Justice, and as part of that budget for that strategy. Where we had a sort of almost a bit of a natural break where the funding was coming to an end, is where we started to look alongside our new team setting up at how well it was working and how well, since we developed a lot and moved on a lot since this was first set up by a colleague who was very much focusing on the female offender element rather than specifically out of court. That's where we started to look at, are we doing this efficiently enough, and are there changes that we can make? And that's where we've worked with the centre to rewrite our service level agreement and have a look at what's the best practice as things are now.
Okay, Martin, did you want to add anything?
No, just echo that and just reiterate that it's communication has been key in resolving that, and having those honest and frank conversations. Here's what we need. This is what's going wrong for us. What are the impacts to you as well? And then just flashing that out. At the end of the day, we all wanted the same outcome. So it actually wasn't as difficult a conversation as sometimes it feels going into. Okay, great. And here's another a question, Fionnuala and Ella, for you really, which is it's from Sandra Beaton. So it relates to the role of chief constables, as you mentioned the importance, and I wanted to know a little bit more about the willingness, the unwillingness to implement out-of-court disposals, some of the reasons as to why that there's been an unwillingness or a willingness, and whether you've got any more to add on that front.
Yeah, I can pick up that one. I mean, so we didn't do research with chief constables directly, I should say. We spoke to out-of-court resolution leads in these forces and about how they thought they'd managed to kind of achieve high use of out-of-court resolutions, and many of them said it's the fact that a big factor is that our chief constable is supportive of these options. They communicate, that all cases don't need to be charged, that out-of-court resolutions are a valuable option, and in some cases that NFA is a valuable option, where appropriate, and that kind of trickles down through the communications that goes out to frontline officers, and it can obviously have an impact on that, the senior leadership's willingness to fund things like central teams. We also talk a bit in our report about performance measures and targets, and it's a little bit of a dicey subject, I know, because targets can be unhelpful and perverse. But there was one example from one force, for example, where the kind of senior leadership was supportive of out-of-court resolutions. They recognized that they weren't being used as much as they'd like them to be, so they introduced a target where every officer, frontline officer, had to use at least one out-of-court resolution per month. So that's not many, obviously. You hope that that would not have a perverse impact on, and lead to them being overused instead of no further action. But it was a kind of recognition that, police officers need a bit of a nudge to kind of get used to the process of using them, to kind of build that understanding of awareness of the options that are available. So there's just a little bit more on what was going on there. We don't have much of the converse of kind of really chief officers who were really opposed to out-of-court resolutions, because that tended not to be the case in the forces that we spoke to, but we just understand that can be a barrier to use.
Okay, great. So I've got a question which for all of you, but slightly differently for all of you, which is, you all kind of emphasise the importance of comms in this sphere, and the kind of the particularly within the policing context, both within the organisation. But I was interested in your thoughts on, I suppose, other partner organisations. So the Magistrates Association had an intervention relatively recently in which they wrote about or the concerns around shadow justice in terms of out-of-court disposals. And I wondered to what extent convincing some of those other partners is crucial. So, and particularly in Sussex, the extent to which you have good relationships with your magistrates, you have good relationship with some of the others in the criminal justice system, and the importance of keeping them on side as part of the kind of that wider partnership approach. So maybe I'll start with Claire and Martin, and then Fionnuala and Ella can.
Sorry, you go ahead, boss.
Yeah, no, I was going to say, yeah, no, we do have we do have really close relationships with our magistrates, and it's important just kind of procedurally, really, because there are cases that don't come to us, that they officers take to CPS and they get charged that could have come to us. I mean, we are working on that internally by actually now making the use of the gravity matrix mandatory on their CPS report. So actually, they are now having to think about out-of-court resolutions whilst they're writing to CPS. So that's having some impact, hopefully. But yeah, with the magistrates, they need to know, what the process is and what's available to them, because there are those cases that go into court and then come back again. So the magistrates need to know kind of what the process is, how long that will take, and that we encourage that use. And we have those processes and we have those agreements with CPS about how we can best do those most effectively. So we have our multi-agency scrutiny panel, and we have magistrates sitting on those panels as well. So that gives us an opportunity to test the waters with what they think should be an out-of-court resolution, and then kind of address whether that would or wouldn't have been, and what the process would be. So we can also keep them up to date with all those changes as well, so that we've got that ongoing communication.
I can just reflect a little bit as well. I mean, I think with out-of-court resolutions use and kind of confidence around them, the issue is, I think there's not always system confidence. So the Magistrates Association report being one of them, one example of that. And that's an issue because, in some cases we want the courts to be thinking, oh, this case before us here, we might end up giving it a fine, but perhaps it would be better to push back to the police for resolving out of court instead. We think that would be really useful if the courts were doing that, if prosecutors were thinking about that more, and if magistrates were too, So if they're not on board with, if they're kind of not supportive of these options, that's a bit of a shame. But, often kind of public confidence gets mentioned in this context. And I have to say, from our research with the public and research with victims, people don't know what these options are. They think justice, they think courts and prison. And even victims, whose case was resolved by out of court resolutions, they sometimes don't even know what was involved. So I think, but when you talk to them, the public or victims, about out of court resolutions, they're generally on board as long as they're kind of delivered meaningfully and the victim voice is heard. But I think there's a kind of system confidence issue, which, scrutiny panels done well could address by involving the other agencies and showing them how it works. But I know there's government plans to introduce kind of further scrutiny mechanisms, which might help with that too.
Okay, thank you. So we got quite a specific question here, which is probably for Claire and Martin, which is, when considering special category cautions for domestic abuse, what does that actually look like? What conditions may be applied? Is there ever an increased risk to victims, or are they more flexible in the way they protect victims?
Well, I guess as they come to me to look at, I'm probably best answering that. So for the conditional cautions, obviously, there's the DA conditional caution principles, which we'll always adhere to. Anyway, for those special categories, those are just the CRs. They obviously are only non-intimate, so that is one of the additional criteria we look at. If it's an intimate case, we will not CR that for all the guideline reasons. We will also only accept those that are standard risk. We're quite fortunate that both Claire and I, in our previous lives, worked in our public protection departments. My career up till now has been built on domestic abuse and improving the outcomes of that. So I do take a very critical eye at those. But the fact that referral comes through to us before any paperwork is signed, it allows us to have a really close look at that and make sure that the CR is the exceptional outcome, and that is the key word that we use with our officers. It should be by exception. It should be the best outcome with no other option. So if we look at that and we say, actually, this could be a conditional caution because it meets all the criteria for conditional caution, we will upgrade it to a conditional caution because of the seriousness of domestic abuse. So it will only be where we don't have, we fall just a little bit short of that evidential criteria, whether the conditional caution may have some additional impact on a victim if they're particularly vulnerable, if there's that risk that they would end up going to court because of non-compliance, for example, then the CR might just be a little bit of a safer way. But in terms of the outcomes, the outcome that we have for our conditional cautions is a DAR principled course that's led by Interventions Alliance called the CURB course. And we can utilise that for CRs as well. So actually the outcome that the offender gets is still the same, and it's a holistic one-on-one 6-session course with that with a DA specialist, or we can look at what else is going on in this household. So we have used our Women's Centre for some of our non-intimate DAs, where the offender, being a woman, has a number of complex needs, and actually that's kind of spilled out into a non-intimate DA offence. So yeah, we do look at them really closely and really holistically.
Great. Martin, well, just so I have you, I was interested to hear what you were saying about the modelling that you did in terms of the economic benefits and etc. Of course, one of the challenges there is that a lot of the economic benefits don't actually fall within the policing realm. And of course, a lot of that is elsewhere in the system. And what the implications of that are. And I know that has led some teams where they can draw in some resources from police and crime commissioners or their equivalents who have a slightly wider purview, but obviously convincing police who have, a narrower purview is probably harder. But I was interested to hear about the work that you've done on that.
And we are fully funded by our own budgets. We don't have any additional funding coming through from our PCC's office, and it really was just the selling of it being an investment. Yes, this model of team is a little bit more expensive running day to day, but actually there's a there is a benefit and a savings benefit to that, in terms of then that frees up those, that officer time, which is much more expensive to go and do things that civilians can't do. Our team is staffed by civilians who are, by nature cheaper. So it invests more in that response and more puts people back on the streets much more quicker, but also it does pay out when done effectively. We know that Alcohol Solutions does decrease reoffending. If we're getting less crimes through, then actually we are spending less money on dealing with those crimes. And we have a Power BI dashboard which was very helpful in showing how much an offence costs, and then we could liken that against the community resolutions and say, well, if we can reduce just 10%, this is how much money we'll save. And that paid for the team itself. Great.
Listen, we're out of time, and it's been really fascinating, and thank you for your contribution. I'm going to leave the final word, though, to Tina McLeod, who, if anyone knows about all of this, Tina does, because she's been supporting you all for a number of years, in which she said, it was great to hear the amazing work that you've all been doing in Sussex and elsewhere. This only happens with a lot of hard work and perseverance. And she would be interested to know whether there are anything left in your modelling, tools or delivery that you would like to do next to address any gaps that may exist. So there's a kind of a challenge for us to all keep working forward. There's obviously lots still to do in this area, both nationally and locally, but it's really good to hear from you, and lovely to hear about the work that Transformed Justice has been doing and continues to do in this important area. So thank you all. Thank you for everyone for joining us, and do keep in contact with the Vulnerability and Policing Futures Research Centre. Okay, bye.
Thanks, everyone.
Thank you.
Thank you.